Good afternoon, Mr. Abear.
Good afternoon, ma'am.
My name is Cheryl Renazza. Your case has been assigned to me, and I've reviewed your case, so I'll be asking you some questions and entering some information into the record. So would you give us your age, Mr. Abear?
I'm 49.
And you've been in jail how long?
24 years, 5 months.
Almost 24 and a half years of a 50-year sentence. And how long have you been at the barracks?
11 years, 9 months.
Okay, almost 12 years. I want to talk a little bit. I do have the information in the record, but I want to hear from you what happened. I mean, this is attempted first-degree murder. We know that the victim still suffers and will suffer for the rest of her life. As I read the information at the time of your arrest, the victim was 2 months old.
Yes, ma'am.
And was suffering from 6 broken ribs, broken wrists, broken legs, detached retinas, brain injury, and so forth. So I want you to tell us what happened. Well, it's my understanding that you and the victim's mother concocted some story about what happened to her, but later, after you had overdosed on Tylenol, you gave a different story. So tell us what happened.
On the morning of June 24th, 1997, I woke up later that morning. I had worked the night before till 11:30. My wife asked me to change the baby and bring her to her in the bathtub. She was going to give her a bath. I asked her, I said, what's wrong with her? She said she had been crying like that since 4 o'clock that morning. So I took her and started changing her. You know, she was full of poop and everything. And in the process of that, I shook my 2.5-month-old child, my youngest of 5. I brought her to my wife, dropped her off in the bathtub where she was at, and she gave her bath. Called me later on. I got her dressed, and I thought she went to sleep. A little while later, she started having seizures, and I asked my wife to call the doctor and explain what was going on. He said it was nothing, bring her in at the doctor's appointment. So I said, a little while later, I said, things still ain't right. I said, call, and he said, bring her in. And that's where he felt it was spinal meningitis, but later on, they diagnosed her with baby shaking syndrome when she got to Optimus Hospital that night.
Well, and it seems like it's a little more than that, but you submitted a clemency application, but then you became parole eligible. So here we are today for a parole hearing. And the version you just said is different from what you put in your clemency application. And then it's different from, what you told the police when y'all were at the hospital with the baby.
Right, well.
So that's concerning a little bit to me.
Well, right. In a police report, I had mentioned that 2 weeks prior, I had a situation with her as well. And that's led to this, that I had shook her 2 weeks prior to that. And in my clemency application, I put in there that I was late for work. I had work up that morning late for work, which the discrepancy in that is that I actually had permission from my boss to come in later because we were doing a loadout the night before. And that's why I was late for work that morning.
All right. And you were offered a plea deal. You accepted a plea?
Yes, ma'am. They had offered me a plea bargain of 6 years, and I had agreed to it. And they said, we're going to have to set a date for your victim's family to make a statement against you. And I said, okay. When we went back, they said the plea bargain was now 15 years. I was going to take the 15 years, but my lawyer advised me not to take the 15 years, which now he has passed away, Nova Rose. That's why I didn't take the 15-year plea bargain, because he advised me not to.
All right. So let's talk about 25 years in prison. Let's talk about what you've done since. So this is what I've noticed, and then you can fill in. So in 2000, it looks like you got your GED in 2000. You were at Angola, you worked on the arena expansion. I see some certificates of accolades in your record for that. You went to the Bible College, New Orleans Baptist Theological Seminary, graduated in 2007. You're an inmate minister. You went to State Police Barracks in 2009, and you're now working or have been working at Just Tech for about a little over a year now. What do you do at Just Tech?
I cut grass along the roads, keeping everything groomed up, keeping everything cleaned up around their training areas and stuff.
And so that's so before Just Tech, I guess you were somewhere else for State Police?
When I got here 11 years and 9 months ago, I was at Just Tech cutting grass. At the time, Captain Board needed me to fill in a position as a clerk downtown because of my college education, that I was able to handle the clerk's job. So I did that for the police barracks, and then they brought me back. I've been here a total of about 3-4 times at Just Tech cutting grass and cleaning up.
What office did you serve as a clerk?
Fleet operations.
Fleet. Okay. So tell me about your history. Do you have any substance abuse in your background?
I was a sociable drinker when we go to the club or something like that. I never did narcotics or nothing like that.
Okay. Tell us about, I noticed in the record, you've been married 3 times. Of course, you have one child that's here today with us. And then I noticed you had 4 other children from another marriage. I assume we'll hear from your daughters shortly. And then there was another marriage with no children. I want you to tell us and everybody here why you think we should, this is a horrible crime. The victim, bless her heart, is still suffers, will suffer for the rest of her life. Why do you think we ought to give you favorable consideration?
Well, I know that, there's no amount of time can make the horrible situation right. And I took full responsibility at the very beginning of when I got out on bond for those 5 months. You can see in my packet, I went and got a mental evaluation done. I had one-on-one counseling. I did parenting classes, behavioral management classes, conflict resolution classes. I've taken parenting 1 and 2. I've taken victims awareness. I've taken living in balance. I just graduated last night for the 3rd time for anger management, because I believe it's important to stay grounded in the fundamentals of anger management. I've done 24 and a half years without a write-up. I've shown myself to be a model prisoner, and I just pray that y'all would find favor in that.
I did mean to mention your excellent conduct record. Thanks for mentioning that. I had it written down. I forgot to mention it. Let me ask the folks at the barracks what they'd like to say. Sir, can you give us some input?
Yes, ma'am. Rocky, as he's been here, he's never been any issue for us. As he says, he cuts grass here. It's a 1,600-acre facility, and he cuts grass where he's needed, and very little supervision. So other than that, we've had no issues out of him at all.
All right, thank you. I don't have any other particular questions, and I don't see any from my colleagues, so I'd like staff to introduce those who indicated they'd like to speak today.
First, we will hear from Mr. Kerry Myers from Louisiana Parole Project.
Thank you and good afternoon. Kerry Myers with Louisiana Parole Project. As you can see from Mr. Hebert's record, number 1, he has no previous criminal offenses. Nothing in his juvenile history, nothing beyond this. No disciplinary write-ups since he's been incarcerated. So while this is a very serious offense, I think that Mr. Hebert's work on this, also his deep remorse, I think his remorse is deep and wide. Certainly, if he could change this, he would, but he can't. He can certainly be more of an asset to the care of his daughter if he was working, providing assistance for her care. That would certainly be an asset in that way. just based on all the work that he's done, the therapeutic work, I think that Mr. Hebert has shown that while I'm sure he's been searching for answers for this for the last 24 years, it may never find an answer to it. But I do believe that Mr. Hebert is a person who is rehabilitated, presents no threat to public safety, and based on his record and his ability, he has a reentry plan through Parole Project, and then with his brother, he has employment, and I believe he would be a much more a greater asset outside of prison than he would be incarcerated. So I would ask this board to grant him parole.
Thank you.
We will now hear from Mr. Rene Hebert, brother.
Yes, my name is Rene Hebert, and Mr. Carey is right. I do have a job for my brother when he does get out. I have many jobs. As everybody knows, the hurricane has affected us. I own a construction company and an engineering company. We have a house for him to live in that's not is down to buy us. We have transportation for him to get back and forth to work. And I do believe over the years of seeing him from where he was to where he is now, he has changed as a person. And if there's anything in the past he would change, that would be the one thing that he would take back in a heartbeat. We all have felt this. I've been raising since he's been locked up. My daddy has dementia, which is in the background. My mama has AFib, which they both live with me. And I'm taking care of them besides running my two companies. So him being out would definitely help me and take a load off my shoulders and also benefit the society in a positive way.
Thank you. We will now hear from Ms. Haley Hebert, daughter.
Yeah. Hello. I'm Haley. I'm 31 years old. He's been in prison for 24 years. I started visiting him whenever in 2010. So it's been about 11 years now. We've grown a relationship. I would love to see a relationship outside of prison with him. I've seen, he seems like he's improved and everything in his life, and he's not angry or anything like that. I did just have his grandson. He's 4 weeks old. I'd love to have a relationship with him. But yeah, that's about it. I'm sorry.
Thank you. We will now hear from Ms. Sierra Hebert.
Hello. He went to jail when I was just about 2 years old. I'm 28 now. And I missed a lot of my life growing up without a dad. I'm sorry. I would just like to get to know him more. And not to have to miss any more milestones. I think that's all I can say right now.
Thank you. We will now hear from the opposition side. First, we will hear from Ms. Sarah Carline, the victim's mother.
Hi, my name is Sarah Carline. I am Andrea's mom. I'm speaking on her behalf because she can't speak, she can't see, she can't talk, she can't walk. Her milestones were forever crushed. June 24th of 1997 when he took her life away. This is Andrea. Andrea can't do anything because of what he has done to her. She has seizures daily. She's a quadriplegic. She's diapered. She's been through 17 surgeries and still needs more. She's tube fed. She can't even taste her own birthday cake every year. 24 years she's been like this. Remorseful, he has never once said he was sorry for what he has done. He shows no remorse. Whenever he was let out on bond before his trial, his stipulation was to pay child support. A stipulation to stay out of jail till your trial was to pay child support to this innocent infant. He paid nothing, nothing. His family wants to talk about how he's going to get out and help. He's going to get out and provide for her or support her. He's not. He's not. He didn't do it to stay out of jail. And I hired a lawyer and had him put right back where he belongs. He deserves to serve 50 years. She has a life sentence. He needs a life sentence. That's how I feel. Family outings for Andrea. She goes to the doctors. She goes home. That's her family outings. She has suction machines. She has so many machines at home that we have to carry around if we go somewhere. She has a little sister. She can't even see her face. You know, like her sister's 14. This is all she knows. You know, she can't talk. She can't see. She can't do anything. Her stepfather has been in her life for 19 years. That's her father. That's a man that stepped up and took on this responsibility of somebody like Rocky Hebert to destroy. You know, family support. I have family support. I have my daughter, I have my husband, and I have my parents. That's Andrea's family. Rocky's family has done nothing for Andrea, nothing. He will not do anything for her. His sentence was 50 years with no parole and no probation. 10 years in Angola, 10 years. And he's been at the State Trooper Barracks for how long? 11 and a half years. It's not enough. It's not enough. Thank you. Thank you for your time.
Thank you. We will now hear from Mr. Mark Rhodes.
Madam Chairperson, members of the board, my name is Mark Rhodes. I was the first assistant district attorney of the 32nd Judicial District Court in Terrebonne Parish. I have been retired for 5 years now. I am a liberal Democrat who believes in and practiced restorative justice. I hired many lawyers over my 30-year career, and I always told those young lawyers, this job is not about putting people in jail. This job is about bringing justice to victims and going the extra mile to keep people out of jail. But sometimes within that philosophy, there is an argument for harsh punishment. This is one of those times. Mr. Hebert mentioned that there was a plea bargain. Let me explain to you what happened. I had finished the term with the previous administration, taken a sabbatical. When I came back again as first assistant, and I asked my secretary, who had been my secretary, I said, what's on file? And she dropped Rocky Hebert's file on my desk, and she said, this is a travesty. And when I opened the file, I couldn't believe what I saw. He's right, there was a 6-year deal, and there was a 15-year deal on the table, and it took my breath away. So I patiently waited till the deal expired, and I immediately filed a bill for attempted first-degree murder. So as far as the plea bargain, it was because of the cowardice, and I will say that, of the lawyer that had the file, who was fired, not just because of that, but that did not help that lawyer's case, for fear of going to trial. I need to impress upon you, and I'm sure you know that, but it's paramount that the board knows that by charging him with first-degree murder, that carried a specific intent element. That means that this jury found that Mr. Hebert's goal was to kill Andrea, but he failed in that goal. specific intent to kill. And a lot of people were arguing to go for a lesser charge because specific intent is such a high bar to meet. And I knew we could meet it, but we agreed as a family that we wanted to take the sentencing away from the court, not because I had no faith in the court. I think the judge was a good man. I wanted the court not to have to impose sentence. I wanted the legislature to impose sentence, and that sentence is 1/2 of life, 50 years without benefit of probation, parole, or suspension. So that was not overcharging in an attempt to get a lesser verdict. My style as a prosecutor was to tell juries, if you're going to come back with a compromise verdict, then walk him. I didn't play those games. I went for an attempted first-degree murder and got one. And you know how we got that? Because the expert testimony was so graphic. The two physicians that testified were asked to give examples in layman's terms so that a jury could understand what type of trauma would it take to cause this. Because we had a lot of medical testimony about the inside of the skull and the brain rocking back and forth and the optic nerves and the petechia and the eyes and all of that. He said, well, it would be like if you took a baby, this age baby, a 2-month-old baby, held it by its feet and dropped it head first off of a 3-story building. Or if a baby was in a stroller and got hit by the front of a car that was traveling at 45, 55 miles an hour rate of speed. Or if a full-grown adult male had a baseball bat and swung with all the ferocity that they could summon up to strike someone in the head. Those are the types of traumas that were necessary to cause the amount of damage that Andrea suffered. This was not only a heartbreaking crime, it was a vicious crime. And Mr. Hebert has shown no remorse into that. What does Mr. Hebert have? Well, he has the ability to communicate with his family. When someone sends him a gift or puts money in his commissary account, he can feel love. For Christ's sakes, he's been married at least once since he's been incarcerated. He's at Jackson Barracks. With all due respect to DOC, we have men sitting in jail for nonviolent drug offenses for decades who don't get out of Angola. Mr. Hebert is at, let's face it, he's at the Four Seasons of DOC. I've been to Jackson Barracks, okay? I know what the conditions of Jackson Barracks are like. Do I want to live at Jackson Barracks? Absolutely not. If I'm an inmate, do I want to be at Jackson Barracks? You better believe I want to be at Jackson Barracks. What does Andrea have? Well, let's go back. What does Mr. Hebert have? He has the ability to read and learn and better himself and engage his mind. He experiences life. What does Andrea have? None of that. And quite sadly, nothing that resembles life as we know it. She's 24 now. She should be educated. She should be probably married. She could probably be expecting her own child. She has none of that. She has nothing of what we think of as life. She has the love of her family, but she doesn't have the ability to realize the depth and breadth of that love. Because I've been in this room for 45 minutes and the amount of care this child has had to require is overwhelming. I don't know if any of the board members have ever been a caregiver, but if you've ever been a caregiver, you know how all-consuming that is. And these people do this every day, all day, and all night. He didn't only take Andrea's life away, he took his mother's life away. Andrea's mother, Sarah's life away, his grandmother's life away. Now that her husband, she's remarried, his life is compromised, their child's life is compromised. And it's going to go on in perpetuity. There is no end date of this. It's never going to get easier.
Mr. Rhodes, could you wrap it up for us, sir? We appreciate.
All right, I understand. I just want to express how vehemently I oppose this. And I want you to understand, that's not a typical prosecutorial response that you're looking at. I am a compassionate man. This was a horrific crime. And I cannot, in good conscience, not be emphatic in opposition to it. I respect the difficult job that you have. I really, really do. And like I said, I am a fan of restorative justice. Sometimes within that philosophy, you need to have harsh punishment. And the reason we went for first-degree murder was to take the sentencing away from the jury and impose a minimum mandatory. And it's not fair that we took that risk where we could have got a compromise verdict, and that now the legislature is taking away that minimum mandatory without benefit of probation, parole, or suspension. I thank you for your time. I apologize if I come across as a little harsh, but in 5 years of retirement, this is the first time I've agreed to come to a parole hearing, because this family stays with me. This case stays with me. I lose no sleep over Mr. Hebert's situation. That's his consequence. Their consequence is this child. Mr. Hebert's consequence has an end date. Theirs does not. In closing, since Mr. Hebert is a minister now, I would refer him to Matthew 18:6. If any one of you causes one of these little ones to stumble, it would be better for them to have a large millstone hung around their neck and to be drowned in the depths of the sea. I want to thank you for your time. I wish you Godspeed in your deliberations. Thank you so much.
Thank you, Mr. Rhodes. All right. Mr. Hebert, this is your
Yes, ma'am.
opportunity to make a brief statement, address your remarks to the panel.
Yes, ma'am. First and foremost, I'd like to take full responsibility for my actions. I was in a downward spiral, and I knew I needed help. And I apologize to through the board. I'd like to say I'm sorry to the victim's family for the changes and everything. To my victim, my daughter, I am truly sorry for this. And there's not enough words in a day that I could speak to express my remorse. And I am truly sorry for this situation. And one thing that victims awareness taught me, that it's not just the primary, it's the secondary and tertiary victims that suffer. And I think about all this every day, and this is what drives me to be a better version of who I was the day before, because I don't want to be that horrible person no more. Nor do I want to cause pain to anybody else outside of that. I truly apologize for my situation. And I don't want to make light of it by calling it a situation. I mean, it's horrible. You're right. I apologize for it.
All right. Thank you, Mr. Hebert. Mr. Roche?
I have no questions.
Okay. I think the panel's prepared to vote.
Yes,
Mr. Hebert? I'm gonna tell you, this is difficult. I realize the good work that you've done. Not having any write-ups in 25 years is just remarkable. When I sat down to read the facts of the case, because your case was assigned to me, I had to get up and walk away from it several times. I was so upset about it. And then today we get to see Andrea and your daughters and all the pain that's been ongoing for years and will continue. For me, I think you're doing good work. I wish you well, but I'm just not sure. I'm just not ready today. Listening to all the pain from all sides today, my vote today is going to be to deny your parole. I would encourage you at some point to write back. I don't know that would be my position in the future, but today it is. So that's my vote. Ms. Jackson.
Mr. Hebert, likewise, I agree with Mr. Rhodes. There's some crimes that there's not enough good work that you can do to overcome. the devastation that you caused. And I'm going to be frank with you. I didn't see any remorse when Andrea's picture came on the screen for you to see. It was as if it was nothing. There was nothing there. The only emotion you showed was when your other daughters were, pleading for your release. I don't think you were honest about what happened in this case. You minimized what you did to cause this devastation with this child. And so you can't, in essence, lie about what you did and then in the same breath say you're remorseful. That doesn't ring true to me at all. So my vote today is to deny because of the seriousness of the offense, the continued suffering of the victim, and the opposition from the victim's family. And for those reasons, my vote today is to deny.
Mr. Roche?
Thank you, Madam Chairman. Mr. Hebert, I sat here for the last 40 so minutes and looked at you. No emotions other than when your adult daughters spoke in favor of your release. Other than that, I saw no emotion, no remorse. You can say you're remorseful, but that's not enough. You were given a chance to support your child, which you disabled, when you were released from supervision before your trial. And according to your wife, you not one penny. And you were revoked because you didn't do what the judge asked you to do in the conditions of your release. And I want to let you know, I read every word of your file. I read the letters of opposition. I read the letters of recommendation. I made my decision long before the victims appeared today. So don't think the testimony by your former wife and former DA swayed me in any way. It was the facts, the opposition I saw in the file, the express opposition from the victim's family. And what's so sad about it, Mr. Hebert, the victim cannot oppose because she doesn't have the ability to oppose your release. You're responsible for that. Along with opposition, I think it's insufficient time. There's no way that 24 years of incarceration can compensate for what you did to that child, your own child. You need to go back, think about actually what you did in the state in which your child is today. My vote is to deny your request for all the reasons stated.
All right, you've received a unanimous vote this afternoon, Mr. Hebert, to deny your request for parole.
Thank you.
Stay the course, keep doing good work. Thanks, everybody who participated this
Thank you
afternoon.
for the opportunity.
How can one not watch this hearing and just feel hatred for this monster? At the same time, how can one not watch this and just feel admiration for the DA that shows up? And this is what I always rage about on this channel. If you're familiar about it, I always get so upset. And here we have the the DA who comes out of retirement after 5 years to stand up for what's right. He came up from his hiatus to see that one of his lousy attorneys, what's the word he used? Coward, who was going to give a plea deal, what, a 6-year plea deal to this monster? Someone with a sense of justice. If you could come back out of retirement and you could layer the system with someone like that, I think that we'd actually go places. The idea that what he said is he was going for broke. He was going to say, no, this is going to be an attempted first degree. We're going to get the full charge. We're going to make sure that there's no option but for the judge to sentence this monster to the maximum. And to think that if he had just signed the appeal papers, the deal papers faster, we would never even know this case existed. And travesties like this happen all the time. I want to point out we're going to go over the documents. We're going to go over the details of how terrible this crime is. And we're going to do it just so we can show what a despicable, disgusting monster Rocky Herbert is. And to remember that he started off this hearing by literally saying he was changing a diaper. It was dirty. Then he shook the baby. The baby put the baby to bed. Oh my, this guy. If he couldn't try to downplay this thing more, it's unbelievable what the DA said, how he described those injuries. I thought everyone handled this hearing just perfectly. Mr. Roche, Miss Renata, she said that while she was watching this, she had to get up and walk away in disgust when she was reading the reports. Miss Jackson, I'm going to point out that the only time he cried was when his daughter spoke. But when his other daughter, who he put in that condition, came on, there was nothing. And to think that one of his daughters actually said, I had a son a month ago and I want him to. Really? You're going to trust your 1-month-old son with that monster? Let's remember this baby was 2 months old when he caused this destruction to her little body. We'll go through it. I don't know why dryers make all this sounds. It's like, I get it. It's done. About a month after she began dating the petitioner, because he appealed his sentence for a bunch of different reasons. It was funny. He appealed. He sued the DA or something. He doesn't. This DA came after him. He couldn't believe it. He had all these weak attorneys, these coward attorneys that were handling this deal. Little did he know he was going to meet a real man, a real attorney, a real law practitioner who understands what his job is. About a month after she began dating the petitioner, Sarah discovered that she was pregnant. And it's just, they're dating for 1 month. She discovers that she's pregnant. So they decided to get married. They moved several times during the course of her pregnancy and had financial difficulties due to his lack of work. This guy is just a complete, waste of space. The baby, a girl named Andrea, was born 1997. After an uneventful pregnancy, her condition at birth was completely normal. During her first 1.5 months, Andrea was seen by her pediatricians. during her first 1.5 months being by pediatricians for well baby visits and for respiratory infections, a common illness in infants. On June 14th, now pay attention to these dates and pay attention to his story. On June 14th, 1997, a hematoma on the baby's head was brought to the attention of the doctor and x-rays indicating swelling but no broken bones. Okay, this is June 14th. Since there was nothing in the history to indicate that the baby had fallen or was dropped, and a hematoma could happen in a variety of ways, child abuse was not suspected. The baby was seen 3 more times before her June 23rd, 1997 follow-up appointment. At this visit, Andrea's weight, which had fallen, returned to the level it was on June 11th. There were no visible signs of trauma, and her upper respiratory infection was improving. On June 24th, the pediatrician office received a call from Andrea's mother who was worried about the baby's condition. The infant was brought to the office and examined by Dr. Robert Clark. When examining Andrea, the doctor noticed symptoms which indicated an altered level of consciousness and some brain damage. Dr. Clark personally rushed the baby to the hospital's emergency room, which was adjacent to the office. Dr. Clark suspected spinal meningitis and ordered tests before the baby was transferred to Ochsner Hospital in New Orleans, which has a pediatric intensive care unit. Subsequently, Dr. Clark received x-ray results which showed that Andrea had multiple rib fractures in various stages of healing. Remember his story? All I did, she had a dirty diaper and I shook her. I shook the baby, he said. On that note, you know how many times he said, I am sorry. I am sorry for the situation. I am sorry for this situation. He said that, I think, 4 times until the end. He said, I don't mean to belittle it by calling it situation. And then he said it one more time. Dr. Clark notified the doctors at Ochsner of these results, and subsequent x-rays revealed that the baby had a broken leg, 2 broken wrists, which were already healing. Because the x-rays indicated severe trauma and child abuse, the Houma Police Department was notified. On June 25th, police detectives investigated the baby's injuries, met with the petitioner and his wife, advised them of their rights, and conducted interviews. Neither parent admitted to knowing how the injuries occurred. On June 27th, the parents were again Mirandized and interviewed. Again, petitioner did not admit to injuring the infant. In the early morning hours of July 1st, petitioner attempted to take his to unalive himself, and I don't say that in jest. I say it because of YouTube, and was taken to the Terrebonne General Hospital emergency room. Because petitioner said that he wanted to talk to the police department was notified, and the detective Hogenstead went to the hospital. At that time, petitioner told detective that he had shaken the baby on June 24th. Detective Ashley Richardson went to the hospital later that morning and took statements from the petitioner. In this statement, petitioner admitted that on June 24th, Andrea was whining and that he shook her for a few seconds before she started having seizures. A few weeks earlier, he had shaken the infant when she was crying. He did not recall if he squeezed her, but admitted that Andrea's broken ribs could have been from that incident. Can you imagine the rage and the anger that you need to have to crush your baby's ribs? He denied knowing how the baby received a hematoma on her head, her broken leg, or broken wrists. He did recall, however, that while a nurse was preparing Andrea for the IV, she bent the baby's wrist. Petitioner further acknowledged that he had a bad temper caused by stress. Subsequently, petitioner was arrested. Despite her neurologist's expectation, Andrea lived. She was described at the time of the trial as being blind, having very bad cerebral palsy, being mentally disabled, unable to talk, walk, or roll over, and having seizures. She's living in, really, So I guess they did touch on the previous dates. He did it for like a second, where he spoke about it for a second at the end of the hearing or something. But the petitioner argues that there was insufficient evidence to support the jury finding him guilty of attempted first degree. Specifically, petitioner argues that the evidence was insufficient to support finding that he specifically intended to do it, which was incredible that this DA went after that. Because you could argue that, hey, how is it, how can they prove that? Support of his argument, petitioner points to the testimony of his wife, who testified that she didn't think the petitioner was capable of hurting a child, that he loved the child and shared her feelings towards the child. It does beg to differ how she was unaware of her child's condition. I don't. It's hard to understand that. Unless it all happened, unless they said the injuries were healing at different stages. I don't understand. The child and share her feelings towards the child. I'm sure she feels the guilt though every day, and I can't. It's just I can't judge her on that. He told her to call the doctor after the child was injured. Petitioner also relies on the testimony of Dr. Douglas Postal, who testified that the petitioner appeared to be concerned about the injuries of his daughter, along with his own testimony to the effect that he never had any intent to harm his daughter. In addressing the instant claim in connection with petitioner direct appeal, the Louisiana District Court of Appeals first examined applicable by law. So they go into now, they describe the definitions of intent. Several doctors testified about Andrea's injuries and the cause of them. Dr. Clark noted the x-ray showed the broken ribs were in various stages of healing and indications that the injuries happened in different times. The doctor explained that the bone in a 2-month-old infant is not, I think it's calcified. Rather, because the bones are elastic, it would take a significant amount of trauma to cause a fracture. When asked about the possible causes of the infant's rib fractures, Dr. Clark explained that he had never heard of a baby's ribs being fractured because of trauma to the mother during pregnancy. However, he admitted that multiple automobile accidents could have caused the injuries. He could not say if the injuries could have happened in the 24 hours before the June 24th visit, but stated that Andrea's brain condition clearly had changed during that time period. Dr. Clark acknowledged that the blood in the spinal fluid obtained during the spinal tap could have been from hitting a vein, not the head injury. Dr. Clark agreed that the parents' willingness to bring the baby in for checkups could be an indication they were concerned about her health. They go on. They bring up many doctors. Good for this DA bringing up these doctors to testify. Dr. David Fraker, the expert in radiology, testified that he interpreted the June 24th x-rays at Terrebonne General Hospital. He concluded that the baby had multiple rib fractures, an unordinarily high suspicious finding. He explained that because of the different amounts of callus around the different ribs, there appeared to be various stages of healing and an indication that the fractures did not occur the same day. He opined that the fractures could have occurred 2 weeks before or even an earlier date. If the fractures did not occur on more than one day, then they were the result of tremendous incident in which the baby was squeezed significantly. Dr. Fricker further explained that because the rib I mean, they really go into a lot of details. I don't think I can do it. Then he went on to say that he suffered blackouts. Maybe he didn't remember doing it because all he's trying to prove is that there wasn't intent. So there was no support that the petitioner claimed that he suffered from blackouts other than his self-serving testimony. His wife did not recall during their marriage that he experienced blackouts. His treating psychiatrist indicated that blackouts were not a symptom of the petitioner's disorder. Regarding the June 24th incident, he recalled that his wife had bathed her. He took the baby into the living room to dry her. The next thing he realized he was shaking the baby. He did not remember banging the infant's head against anything. Andrea became quiet and put her to bed. When his wife came to the room, the child began having seizures. He denied that he intended to end the baby's life, and at the time he did not believe that he had caused the child's injuries, contradicting his wife's testimony that he did not want her to gain weight during the pregnancy and that he resented the attention she gave the baby, denied that he shook the baby before June 24th or that the detective had done so. Then he tried to blame it on an automobile accident. Then he said that the sentence was excessive. I'll put the links in the description. I think we've covered it enough. All I can say is that evil does exist, and we've seen it right here. And again, the idea that he had gotten out on bail and still didn't pay anything towards the child support. And in his parole hearing, he literally states over and over and over again, I'm sorry about the situation. Horrible situation. It's a situation. He shows no emotion when he sees what he's done to his daughter who's sitting there. And if you're wondering how is it possible that he can even get an opportunity for parole, it's because of Act 122. Act 122, which the Parole Project lobbied for and got approved because it gives the opportunity for inmates who have served more than 20 years and are above the age of, I believe, 40 to have parole. And that bucket gives many parole inmates the possibility for parole, and the Louisiana Parole Project then gets millions of dollars for every inmate that gets out. And they take anyone who falls under their blanket that would be qualified to join the Parole Project, and they don't care. And you can see it even in his statement, which just bothers me. He stands up there and he talks about Kerry Myers, says, oh, he's a great guy. If he could take it back, he would. It's like, really, Kerry? If he could take it back, he would? Is that the best you got? You want to put their family through this? You want to do all the injustice so you can make a few bucks on this guy? And I love what the DA said too. He said not to, what was it, not to make a mockery of the, or in all due respect to the DOC, but there are more inmates stuck on nonviolent possession charges without ever having the opportunity to get out. And here he is spending time at the Shangri-La of DOC opportunities at the barracks. Man, he was so poetic the way that he dropped those lines. Yeah, he's not in Angola. He's in a police barracks. I can't imagine. I mean, it's probably a nice. He's got a nice setup, a nice comfy setup there. And it's just hard to imagine. You see him, how he has like just no. You just didn't get a sense of remorse. Just a despicable human being, a monster. And then to the final mic drop for the DA was to say, okay, he's you want to throw down the Bible stuff? Okay, here's a Bible verse for you. Anyone who harms a child, you should put a large millstone around their neck and drop them into the sea. That was not a mic drop. Well, I thought that we saw what a hearing, what a justifiable hearing should look like in the situations. You have the retired DA come out of retirement. You have the board members, they're all with their mic drop moments, and you have a unanimous denial. With that, I'll let you go.